Welcome to the Safety and Risk Success podcast with me, Christian Harris. My guest today is Matthew Snarr, who is a barrister, and he's been at the bar for over 20 years and specialises in personal injury cases. He does that both for defendants and claimants. He likes to have both perspectives and to keep current as to what's going on both sides of the coin. And he predominantly works nowadays in catastrophic injury and very large cases, but obviously has seen a plethora of different types of personal injury case over the years. I was keen to have Matthew on because I've had interviews before with lawyers about civil claims, insurance claims, but never got to the point of, well, what actually happens when the worst happens and we end up in court. And so that's what we're talking about in this episode. So Matthew shares his insights as to why cases get to court, how cases are won and lost, what it's like to be a witness in a case, particularly from a defendant perspective, and how to position yourself to be in the best possible spot in the unfortunate event that something catastrophic, something really bad does happen and you do end up in court. What do you need to think about as a corporate to be in that best possible position? So I'm sure you'll get a lot from this episode. I really enjoyed it and I certainly learnt a lot as we were having the chat. So I hope you do too. Let's go then to my conversation with Matthew Snarr. Cheers.
Welcome to the Safety and Risk Success podcast with Christian Harris. We believe that proactive safety and risk management powers business performance. Each week we explore this theme, sharing guests, stories, insights, trends, hints and tips. You can find us on all the major podcasting platforms and video versions are available on YouTube. But for now, let's join the conversation with Christian.
Welcome to the podcast, Matthew.
Well, thank you very much for having me here.
Yeah, I've been looking forward to this. We've had a couple, as you know, of defence lawyers on the podcast before talking about kind of claims from a civil claims perspective, but we've never kind of gone that bit further downstream or further upstream, whichever way you look at it, and gotten into what happens in court. So yeah, it should be a fascinating episode.
Looking forward to it.
So let's start then with just a bit of scene setting for anybody that isn't aware. There's a difference, as you'll know and I know, between civil and criminal cases. Could you just explain the difference, so that because that's an important context for what we're going to talk about?
Certainly. Civil, in the cases that I deal with as predominantly a personal injury barrister, involves an individual bringing their case before the court to be decided by a judge. And normally the judge will be deciding whether or not they have been injured and that injury was somebody else's fault, or where fault is admitted, the determination will be what their injury is and what the amount of damages they should receive in relation to that injury. So that is a private case brought by one private individual against another, or a private individual company. In a criminal case, it is normally the state, often the health and safety executive, bringing a prosecution on behalf of the Queen or on behalf of the state. That is normally either against an individual or a company. And the downsides of losing a criminal case, as I'm sure most of your audience will know, are much more severe, in that it can sometimes result in imprisonment, but often will result in a hefty fine if one is found guilty.
Yeah. And back in 2016, the sentencing guidelines for sort of health and safety criminal cases were changed, weren't they? Have you noticed any differences in what's been happening in that realm since then?
Yeah, 2 points. One is fines going up, and magistrates are dealing out bigger fines than they have ever been before, and so too for Crown Court judges, circuit judges in the Crown Court. The value of fines generally is going up, which has meant that business has been paying closer attention to health and safety generally within the industry, but also you're getting more technical challenges because the stakes are higher. So the lawyers are interested in understanding and defining what the duties are in law on their clients, whether they're individuals or whether they are corporate entities. So there's been a lot more activity in the health and safety crime sector since 2016.
Yeah. And that's an interesting question about duties and obligations, because obviously health and safety law in the UK is is built on a risk assessment based approach, isn't it? And there are lots of things that aren't necessarily black and white. Is that fair to say?
Yeah, well, as a personal injury lawyer, I'd probably make my living dealing with this area, which is what is risk? What is a foreseeable risk? Risks generally have to be real. They're not, theoretical. They're not something that will probably never happen. It has to be a real risk, and understanding what that is clearer to some lawyers than others, clearer to some judges than others. And so, as you know, there are cases dealing with the concept of what a risk is and how far one goes or needs to go in protecting employees or others against potential risks which they find themselves. And that's topical at the moment because of some changes happening in the law. In the case of the Nook, recently the government's made some changes that's meant that there are less obligations on individuals who own private automobiles on private land and don't necessarily owe the obligations that they did some time ago, and the government's been making quite a play on that. So it's a moving and changing area.
Yes. It always strikes me as interesting because you have obviously the law, and then you have sort of best practice, and then you have industry guidance, and all of these things, as I understand it, have different sort of weights placed upon them, and so lots of the questions are, were you, obviously I guess you need to adhere to the law as a minimum, but then kind of were you going above and beyond the law to adhere to best practice or industry standards? And I suppose that's where the grey areas are, where you make your living, I suppose.
It is, that's right. And, the courtroom's a somewhat murky world. Lawyers, we have the benefit of 20/20 hindsight. And so we can look back with a perfect snapshot in time of what happened and say, well, you should have done this or you should have done that. And then we have to differentiate between what is a counsel of perfection, as you say, absolute best practice, and what is reasonable. Have you discharged your duty of care? Have you acted reasonably? And again, there are changes in the law there. In recent times, the government has repealed strict liability under the six-pack of regulations, including the provision and use of work equipment regulations. So there is no longer strict liability for deficiencies with work equipment. We're back down to the basic law of negligence in terms of the employer's duty to take reasonable care for the safety of their employees. But concept of reasonableness is a debatable one, and that is one that lawyers continue to debate day in, day out.
Yeah, and that might be one of the answers to this next question, actually, which is that if you think of obviously all of the accidents at work, and then all of the proportion of those lead to a claim, and then what proportion of those actually get as far as going to court, it's quite a small proportion of every accident. But what are the factors, both in a civil and a criminal sense, that actually lead to cases getting as far as going to court rather than being settled or sorted out in whatever way before we get to that point?
Well, the primary factor is if there's a dispute between the parties and they can't agree on whose version of events. And in a civil case, that's normally one of two types of disputes. You either have a dispute about liability, which is the parties can't agree who is at fault, or rather who's to blame. So that if you can't agree it, you have to go in front of a judge, and the judge will decide who's to blame. Often the blame game works on a two-way street. So it may be that the claimant, who is the injured party bringing the claim, is alleging that his employer or that some particular individual has in some way wronged them, caused them an injury by not taking proper care for them. But it's often the case that that individual who is being sued, or the company being sued, makes a counter allegation to say, well, you weren't taking care for your own health and safety. And Christian, as you know from what you do in terms of your focus on slipping, actually that's often an allegation that's made against people not sort of looking out where they're walking.
Yeah,
so,
or if they're inebriated or something.
Exactly. And so the world of fault and blame comes into it. So that is the first example. The second example is where the parties can't agree the value of the claim. That is, somebody has an injury and they're asking for a certain amount of compensation. The parties can't agree how much it's worth. I have to say, from my experience, certainly in the level of work that I do mainly large loss catastrophic injury work. It's much rarer that I find myself in court arguing those types of cases than I do liability cases, because broadly, where liability isn't in dispute, lawyers, contrary to popular reputation, are fairly sensible individuals and will normally find a way through it. Things that will lead to a dispute in court can involve issues of credibility. So where a party's credibility is at stake, and that's a two-way street, but the focus is often on the claimant who's bringing the claim, where their credibility is at stake. For example, in terms of the presentation of their injury. So let's say, for the sake of argument, the defendant doesn't think they're as badly injured as they say they are. That becomes a credibility issue, and that can lead to a fight on a different issue. So it might be that the legal team take the view that, well, there's an argument about liability, and that argument turns on an issue of fact. And because they think that the claimant's over-egging the pudding on their injury, they can persuade the court that their version of the facts on the issue of liability is more likely to be accurate. So that is classically in civil cases where we find ourselves apart. In criminal cases, it's slightly different, because to get to court in the first place, there needs to be a two-stage test. The first is a sufficiency test, an evidential sufficiency test. The CPS or the HSE have to ask themselves the question, is there enough evidence to realistically bring about a conviction on the criminal standard? And that's the first stage of the test. And if there isn't, then that's the end of it. And the second stage of the test is whether or not it's in the public interest. So just to make sure it's not a waste of time or money or an abusive process. So once you get over those two hurdles, you're then likely to find yourself, if they are persuaded that the evidence stacks up, you're likely to find yourself in a criminal court. And those cases that tend to fight are the ones where, again, there's a dispute of fact. Obviously, if the client feels they have done wrong and thinks things should have been done differently with benefit of hindsight, then they will plead guilty. But if they don't feel that they've done wrong, or don't feel that they're guilty of the crime that they're being charged with, then they will defend it. And those cases will find themselves in front of either a jury or in front of a circuit judge or a magistrate's bench.
And the burden of guilt, if that's the right word, is different as well, isn't it, between civil and criminal cases? Yeah,
so the phrase is the burden of proof, because
yes.
In a civil case, the person who brings the claim is the claimant, and they have the burden to prove their claim. They have the burden to establish that the facts of the accident happened how they said, and that they suffered the injury they say they did. And that is on the balance of probabilities, i.e. what is more likely than not. In criminal courts, the burden is to the criminal standard. It's a higher standard. It's so that the jury is sure. In old parlance, it was beyond reasonable doubt. These days, the direction is the jury are sure that the individual is guilty of the offence. So it's a higher standard for obvious reasons, because you're taking somebody's liberty away from them.
Yeah, makes sense. Yeah, I can't remember if I told you this when we chatted before, but I had to do a personal injury claim a few years ago. I was run over. So when I was walking on the pavement, and a car lost control and mounted the curb and ploughed into me. So that was definitely beyond reasonable doubt that that I was injured.
Sorry to hear that. I hope you're fully recovered now.
Yeah, it's one of those things actually that obviously I was not glad it happened, but it does inspire me daily, really, in what I do, because obviously once you've lived through something like that, then you really have that appreciation for when things go horribly wrong, and so you kind of want to help people to avoid that happening to them. So, there was a sort of silver lining, I suppose.
Did the driver accept fault and accept it was their fault?
Yeah, the insurance company accepted liability straight away, because it was there were witnesses and CCTV and so on and so forth. There was no kind of question about liability, and there was we had a little bit of toing and froing on the quantum. But it's interesting, because I didn't really know this before then, that there's the kind of, I don't know what the word is, but there's almost a Bible, isn't there? A booklet of sort of, physical damage. So if you lose your ring finger, it's worth X. And if you lose your thumb, it's worth Y. And if you, depending on which hand it is. And so going back to what you said, I guess the quantum of these things is in many cases quite straightforward to calculate.
It is. There's a Judicial College guidelines for the assessment of damages.
You're looking for it, yeah.
And I was looking for it because it's just changed colour. It's now a bright pink colour, and that sets out what your general damages are, which is your bodily injury.
Yeah.
So yeah.
Yeah. Interesting. So that's why we get as far as court. And in terms of how cases, I suppose, are won and lost, how what does that tend to come down to? What are the sort of deciding factors that will lead to success or not?
Cases are won and lost generally on the evidence, and that is that the judge or the jury have to prefer one person's version of events over the other. And if we stick on the civil side for the time being, the judge has to evaluate the evidence and come to a conclusion and make findings of fact. And so when litigating a case, the lawyers will spend a lot of time head scratching, saying, well, what's a judge going to do when they look at this? And in fact, in the criminal arena, you do the same thing, but you invert it slightly. You say, well, what's a jury going to say when they see this sort of evidence? So they're won and lost on the evidence. Some cases are decided on pure law, but that's less regular. And there are areas where there are arguments as to, for example, whether a duty of care is owed in a particular circumstance, or whether all that has been done that could reasonably be done has been done to discharge the duty of care. And sometimes those sort of blur arguments of fact into arguments of law, but generally they're won and lost on the evidence, most cases.
Yeah. So from a sort of defending business perspective, which would be, I guess, the context of most people tuning in, it's about building that weight of evidence and having as much of that evidence that is provable, I suppose, rather than circumstantial or testimony.
Yeah, you're right. It's predominantly about good documentation. So that's headline point. And good documentation transcends multiple issues. The first is it's got to be clearly legible, readable. It's got to be contemporaneous, i.e. on the day, relevant to what actually happened, not a sort of inspection sheet from a year ago. So good documentation, good contemporaneous documentation wins cases. Judges sometimes are less interested in what people have to say about their case because people's memories can fail them. People's recollection is sometimes not perhaps what it should be, and the mind can play tricks on people. So judges predominantly are interested in documentary evidence, and that takes various forms. It can take the form of emails. Yeah. Particularly in terms of complaints. So if somebody's upset about something and they've complained about it and they've sent an email and there's a log of it, or doing cases involving highways authorities, they'll have a register or a log of complaints from the public. You'll have seen that in the work you do. So good documentation helps defend cases. But then the quality of the documentation, you might have a contemporaneous document that was filled out at the time, but what does it actually tell the judge? Is it detailed? Is it something more than just a tick box? If it's a tick box, is it ticking the right boxes? Has it directed the employee who's responsible for the area where the individual sustained an injury? Has it directed them to the things that they need to be aware of? Has it pointed them in the right areas? But probably important as well are witnesses. And witnesses who are, first of all, prepared to attend court. That can be problematic depending on which sector you find yourself. Some sectors have high turnover industries with employees, and witnesses who are invested in the process. That is, that they care. They care about the outcome because the case with which they are concerned, which they are a role, affects them because they are somebody who is invested in that process, because they should have done something and they are saying that they did do that thing and they care about that rather than not. And then probably lastly is visual evidence, photographic evidence, video evidence. Increasingly in courts these days, CCTV footage, contemporaneous videos are becoming increasingly important. So all of that is important. If somebody says that they fell over on something that was dangerous and you've got a contemporaneous photograph showing the scene to be, not dangerous at all, then you're on to a winner.
Yeah. Yeah. And then hopefully it would never get as far as going to court in that
Exactly.
case anyway, would it? But and to what extent is you mentioned kind of emails and things like that, in the event of a claim being brought, how much sort of transparency is there of that kind of data that's internal to the business, and is there a difference between a civil and a criminal case? You mentioned complaints. If somebody had complained about a faulty piece of machinery, let's say, 20 times, and then 6 months later an incident happened, how far back and how easy is it to kind of delve into the detail of historic things?
Well, let me focus on civil to begin with. In terms of civil, normally the first issue is, have you retained the document? Because if it's been destroyed, and I've certainly dealt with cases where email servers have gone down, people haven't got the emails anymore, we've tried to get them back, we just can't. But generally, every litigant is under a duty to disclose documents which either assist their case or might assist the party's case, or adverse to their case. So the duty to disclose is a high duty, and if there is a document that is adverse to one's case, one is duty bound to disclose it. But as you say, that in part is a systems issue in terms of whether you retain it. The reality is, in a civil claim, as soon as you're put on notice that there is a claim, the defendant will be looking around its documentation and its systems to see whether or not it's got documents that are relevant. And if somebody sent an email to say, this particular area is blatantly dangerous, you need to sort it out, and they haven't, then it'll be one of the first things on the letter of claim to say, look, our client told you about this, you didn't do anything about it, and we said the email was sent on this date, and we're asking you to preserve a copy. So, but actually, in terms of PI cases day to day, emails don't play a massive part. It's normally to do with how the scene was, and normally what people have done, what the movements of individuals have been at the scene. I've dealt with cases involving people falling down stairs, falling off ladders, falling off scaffolds, putting their hands into bits of machinery that they shouldn't do, putting their arms in machinery they shouldn't do. And so often what really matters is not emails, but actually what people did and how they did it, and whether they did what they were supposed to do, and whether they've been told not to do it.
Yeah, I was involved in probably the most high profile slip case in the UK, which was a death in a co-op store in Truro a few years ago.
Yes.
And I've also been involved in lots of brain injuries and arms in deep fat fryers, and it's horrendous, some of the things that happen, unfortunately, isn't it?
Yeah, and going back to your early point about how do cases end up at trial, sometimes end up at trial because there's a genuine dispute about how the accident happened. And that might not be necessarily one side saying, it didn't happen how you say it did, but that is relevant. And contemporaneous medical evidence is also relevant to that issue. So looking at the medical records to find out whether they're consistent. I certainly did a case last year involving an individual who fell down some stairs, an external staircase on a highway, and he suffered a traumatic brain injury. And I was representing the claimant in that case. One of the deciding factors in that case was whether or not the medical evidence was consistent with his version of events and what he'd said, and the judge wasn't persuaded that it was. So triangulating and interrogating the case brought against a particular defendant is going to be important, and they will be looking for as much documentation as they can do. And the presumption normally, certainly in the civil courts, is that the documents, the medical evidence, the presumption is that what is in those documents is probably correct. So if they don't fit your case, you need to understand why that is the case, and why you're saying that they've been written in a way that's different to what you're suggesting.
Just going back, kind of interest to something you said about did people do what they said they were going to do and what they therefore should have done. Something that I often think about, perhaps this is a bit of a trick question in some ways, is, if you're thinking about, let's say, a health and safety policy, if you wrote the very best health and safety policy in the world and it was 100% perfect and laborious in its detail, but therefore was quite difficult to actually implement, versus if you had a health and safety policy that was pretty good but was implemented to the letter, which of those would be
the latter?
The latter.
In any case, particularly if you're defending a case, you need a simple story, and you need a simple solution to what is often a simple problem. So if there's a potato peeling machine and that's capable of being cleaned by somebody putting their hand in, then there needs to be a massive sign saying don't do that.
Yeah.
And if your workforce is Polish, that sign needs to be in Polish. So it needs to be that arises out of a case in which I was involved, where I was representing a gentleman who put his hand in a potato sorting machine. He was my client, and one of the allegations we made in that case was that all the health and safety documentation was in English, and he just didn't understand it. So what you need in health and safety is clarity and simplicity. The more complex it is, the harder it is to understand what you're supposed to be doing, and the scope for confusion and therefore getting it wrong becomes greater. So I would go with the latter on that one, Christian.
Yeah, interesting. Yeah, that's very illuminating and useful actually in terms of many conversations that I have. So yeah, I appreciate that. You mentioned being involved in some falling off ladders and down the stairs, as you say, cases. Have you been involved in many kind of slipping in puddle or slipping on something type cases as well?
I have. I don't do as many of those these days, but certainly when I was a junior barrister out and about in the courts of the Northwest, I did a lot of that. But not so much these days. A lot of what I do these days is concerned with construction, workplace incidents, and also motor incidents where you can get some pretty unfortunate injuries. So that's the mainstay of what I do in terms of finding myself arguing about what happened and how it happened.
Yeah. Okay. And if you're unfortunate enough to be involved in one of these cases from a sort of defence perspective, particularly thinking about, if you're a worker and you've got to come in and give evidence in court. I mean, what's that experience like? I know you're sort of not in that position, but you obviously are very close to it. What does that feel like for people, and how do they cope with that?
I think every case is different, and some cases are more demanding than others. Some cases have a real emotional element to them, and that often depends on the severity of the injury. I think in terms of witnesses giving evidence and what it's like, I think it depends, and that's a bit of a lawyer's answer to a somewhat legal question, but it depends.
My wife's a lawyer, not a barrister. She's a corporate lawyer, so I'm used to getting lawyers' answers.
So it depends on your judge. Some judges are quite passive. They're prepared to receive the evidence and then pronounce judgment at the end, and you never know what they're going to decide until they say right at the end, and then you're either surprised or pleasantly, sort of happy. Some judges aren't. Some judges are extremely inquisitorial, and they want to sort of bear down on the witnesses to really find out for themselves. They don't need counsel as much as their own judgment. Some barristers are more onerous than other barristers, and that of course is horses for courses. Sometimes it gets results, sometimes it doesn't. Some barristers can be really aggressive. That can be quite unpleasant, giving evidence. But I think the main thing for witnesses giving evidence on whatever side you're on, it's important that you know what your evidence is so that you're aware of the facts of the case, and it's important that you just tell the truth. You tell it in an honest way to the judge as you recall it. And I often say to witnesses, I wasn't there. I don't know. And I remember appearing in a case once where I was cross-examining a witness who was making lots of concessions to me. It was all going very well. And the judge said, well, I'm sorry, why are you saying that? He said, well, Mr. Snarr says it's the case, because I was asking him leading questions. I was saying, this is right, isn't it? And he was saying, oh, yes. And he said, Mr. Snarr says it's right. And he said, no. He said, counsel doesn't know anything. All counsel has is his papers and his instructions. Counsel knows nothing. He said, you're the witness. You tell me what you recall. And I often tell that to witnesses to say, no, I don't know. I know nothing. You know, you were there. So when the judge is asking you questions, just tell. And I think that's quite empowering because actually the whole point of the witness turning up is that they're there to tell their story, their version
Tell the truth.
of events. And I think just trying to calm down a little bit as well sometimes. Sometimes witnesses can go a bit quick. They can get very nervous. They can start saying things they don't really mean to say. So, you know, it's a process. You just have to go through it. And if you read your witness statement, you've gone in to tell the truth and you listen to the questions, then that makes the process much more straightforward.
Yeah, I can imagine sort of being cross-examined by somebody that's quite aggressive could be a pretty harrowing experience. So hopefully I never have to live through that.
It can be, although barristers themselves have to be careful with that, because if you're too aggressive, the judge will stop you because you're being mean. You know, I mean, anyone could go in and into an argument in a bar and be aggressive. So that, you know, issues what are you trying to achieve. I think sometimes it can be difficult for defendant witnesses because they are there for the company and they are putting up the defence as to why this particular person's, you know, reached an injury. And in the cases that I deal with, it's often a very grievous injury. And so there will be a lot of close scrutiny as to how we have found ourselves in these situations. And sometimes the starting points of judges in these cases is, well, how is it that this person's lost their arm? Something's gone wrong badly. Starting point is there's a lot of attention on the defendant. So, but normally you won't find yourself in those sorts of situations in a case where you're fighting a case to court unless you've got a pretty clear answer to that question. So
that makes sense. And thinking about judges, then I don't know the answer to this. I'm interested to hear. You obviously specialise in a certain area of law, and you do both claimant and defendant work. And I think I won't put words in your mouth, but I think that's because it gives you good perspective from what you said to me before. When it comes to the judges, are they at all specialists? So would a judge be mostly looking at health and safety related issues or personal injury issues, or do they sort of have a much broader remit than that?
Judges generally have quite a broad remit. So dealing with it in the civil sector, certainly in the court centres in which I work, which will be Manchester, Liverpool, Birmingham and Central London or the RCJ, you're just in front of a circuit judge. Now, more often than not, circuit judges will have personal injury experience. In Manchester, in the lower tier of judiciary, which are the district judges who run the day-to-day cases in terms of the evidence, how the case gets to court, we have specialist ticketed judges who are personal injury specialists. And actually, the circuit judges we have in Manchester have got quite a lot of personal injury experience, so there's no issues there. But you know, you take your judges as you find them, and that's why it's important to have a simple and straightforward cases. And quite frankly, by the time you get to being a circuit judge, you know, one knows one's P's and Q's. And judges will be dealing with very complex, difficult cases. And then if you're in the High Court and you're in front of a QPD judge, they will do the full gambit. They will sit on some crime, they might do some commercial cases, and then they'll listen to some PI. But that's not necessarily a bad thing. And there is sometimes some cross-fertilisation between the law. So, for example, there might be an argument over whether a particular individual is an employee or not. And it might be that the judge hearing the case has done some employment law, or been hearing some employment cases, which gives them some context. So I don't think particular specialism is necessarily key, but generally for the big cases, they tend to be siphoned off to judges that have got specialist experience. And once you get into sort of, your multi-million-pound cases, when you read the judgments coming back from the High Court judges, generally they're people who have been in that area, and the justice system will find itself filtering the more complex cases to those judges because it's their bag.
Yeah, makes sense. Makes sense. It's interesting that a lot of what you've said is about being clear and concise, and it's, you know, I think those are words to live by in all sorts of walks of life, whether that's marketing or talking to trying to persuade a judge.
Yeah, I think that's right. I mean, some people are inherently clear and concise, and that's a gift. I'm not sure whether I have that skill particularly, but I know where I need to get to. So I certainly find in the presentation of my cases, I work incredibly hard to get to the point where the message that hopefully I'm advancing on behalf of my client is clear and concise, and so the judge gets it. But I always remember quite a well-known silk saying to me that, you know, in order to win a case, you need a simple story. It needs to be straightforward. And I think that works for both sides of the fence. And I think also people ask themselves inherently, what's the most likely thing to have happened?
Yeah.
You know, when the jury go back to the retiring room and think about it, well, what do we think really happened here?
Yeah.
When the judge is sat there and the judge goes home and is looking at their laptop thinking which side they're going to fight for, they're going to say, well, what do I think really happened?
Yeah. So if you're relying on too many kind of leaps of faith, then you're in a difficult position.
That's right. That's not to say, for example, accidents don't happen in bizarre circumstances. And sometimes people do stupid things that aren't the most common sense things. And again, those are cases in which sometimes one finds oneself arguing these propositions. But generally, you've got to ask yourself, what's the most likely things happen in this case? And that goes back to the issue of risk, and it goes back to the issue of approach to safety, which is, you know, where do we think the real risks are? I mean, that's what risk assessments are about. They're identifying the real risks, that, you know, the risks that we should be worried about in terms of either the propensity for the risk to realise or the severity of the risk if it's realised. And that's what people are, I think, are interested in, really.
Yeah. So that brings me on to my final question then, which you've given a couple of points here, but what, bearing in mind that the audience is predominantly going to be health and safety, risk management, insurance people, that are therefore from a defence perspective, what should people be doing, or what are the top tips that people can bear in mind to be in that best position possible, that in the event that something terrible does happen, hopefully it doesn't, of course, they're best able to, you know, defend themselves well. So you talked about having a simple story and doing those good risk assessments. What else would you add to that list?
It's funny you asked me that, because I have a list in front of me.
It's almost as if we prepared in some way.
Almost as if we thought about it before. In no particular order. It's partly about systems, and it's partly about behaviour. And so I'll deal with that in turn. But fundamentally, in my view, it's about setting the example and the standard. And that comes from the culture and the ethos of the company. If we're talking from a corporate perspective, that's top down, but predominantly it's the managers. The managers lead. The managers are the example. Employees who aren't managers follow the managers and do what the managers tell them to do or inspire them to do. It's about avoiding grey areas, particularly if you're quite process driven, depending on the type of sector in which you work. Some sectors are more complex than others. There might be more discretion in the agriculture sector than there might be in the care sector. The motor sector is quite highly regulated. So it's firstly about the standard you're setting yourself within your own company. Your systems have to be good. They have to catch errors. They have to catch people making errors. The law will assume that from time to time people will do stupid things, and so you should too. Behaviour is important. Good systems means managers constantly interrogating and checking the systems, checking that they work. So it's not just ticking a box, it's checking whether or not they've properly ticked the boxes, whether the boxes are asking the right questions, whether they can be improved, whether things need to be revised, and also checking that the employees are doing it properly, and if they're not, taking them aside and gently pointing out how it needs to be done. You want clear delineated lines of responsibility. As a barrister, you come in and out of certain types of cases sometimes in your career, and I've come into a row of cases at the moment where there are arguments about who is responsible for doing what.
Right.
And so particularly where you have multiple subcontractors working in the same area, you need to be really clear about who has responsibility to do what, and whose safe system of work are we following, whose risk assessment and method statement is primary. What is the default position if it's not the main contractor? So I think in multiple organizations working together scenarios, you need really clear lines of responsibility. Mm-hmm. But going back to what I was saying earlier, in terms of setting the standard, it's actually about caring. It's about caring about risk. And you'll have seen this, Christian, with the clients that you work with. I've seen it in the cases that have gone to court. The judge will see it, the jury will see it in terms of when they listen to the evidence. You can see it from the witnesses as they come across about whether they really care or not about what happened and how it happened. It's about caring for your employees and ensuring that they care for each other. KPIs, I think, are really important. Sometimes they're viewed as a bit of a dirty word, but actually I think KPIs are really, they're a benchmark. They are a marker point by which you can affect and bring about change. I think it's about going back to what I was saying before about realizing the type of sector that you're in. Some employees are time limited in their job role, but they still need clear induction and they still need clear systems where there can be no errors. I've talked before about people doing stupid things, but we've all done stupid things in our kitchen, in our garden, whether that's putting your hand on the iron or whatever, where with the benefit of hindsight you wouldn't have done that. Sometimes that's due to tiredness, inattention, etc. So it's about understanding that people do that. And then also training people on the legal standards, what they are, how to meet them, but I think always aiming to be above the standard if you can do. You talked earlier about best practice. I think always striving for best practice. So I'm sorry if that sounds like a bit of a lecture, but as a PI lawyer, I was always going to sort of come out with a long list of things. But cultural ethos and attitude to safety can't be retrospectively magicked into existence. No. It has to be there at the time. And I hope there's one thing that will come over from this podcast to your audience is that when the judge looks at the evidence, the judge will see it as it was at that time. And so what you're doing now is that it's important, and it's important you get it right from now.
Yeah, absolutely. Well, that's great. I really appreciate your time and your insights there. I think people listening to this will have learned a lot. So thank you very much for that. Before we wrap up, is there anything that you'd like to plug, or what's the best way for people to contact you? Is it to connect on LinkedIn, for example, or the website, or are you doing any more podcasts or interviews or articles or anything like that? So the floor is yours.
Yeah, this is my first podcast of 2022. That's very kind. Thank you. No particular plug, Christian, other than to say if you want to find me, you can find me at www.9sjs.com. That's where I have a profile, but I'm also on LinkedIn and Twitter. And so if you type in Matthew Snarr, SNARR, you'll probably find me lurking around the social media halls, commenting from time to time on matters of relevant to my industry, personal industry. I try to, if I can, stay away from other areas.
Yes, I think that's sage advice. If only everybody did that on social media. Yeah.
Anyway, but thank you very much. I've really enjoyed the discussion today, and I think we've covered some really interesting topics, and hopefully it'll be of use to your audience.
Absolutely, no, really appreciate it. Thank you very much, and thanks to you for joining us as well. And I look forward to catching up with you next week for another interview. Cheers.
Great. Thanks, Christian. Bye-bye.
Thanks for joining us on the Safety and Risk Success podcast. If you've enjoyed this episode, please hit follow and do share on social media. Does anyone you know spring to mind as a great guest, even yourself? If so, please contact us on podcast@slipsafety.co.uk. See you next week for another episode.